to silence its opposition.
It's a propaganda machine.
It's propaganda. If this bill passes the Senate, should the Governor-General, under the Constitution, exercise reserve powers and refuse to grant royal assent to this bill, therefore terminating it. At the time of recording this conversation, the Communications Legislation Amendment Combating Misinformation and Disinformation Bill 2024 has been transmitted to the Australian Senate. It passed, I think it was on Thursday. This is Saturday now, so on Thursday it passed or Sunday now. Well, mind in other places.
Yeah.
But on Thursday it passed the House of Representatives, and it's on its way to the Senate. Morgan, you've done a lot of work on this bill. I first of all, I want you to put in as simpler terms as possible what this bill is, and then I want you to attempt to integrate this bill, this concept of what I think I may call censorship, into our conversation that we've been having.
Yeah, so it's quite a complex and unprecedented attempt by the government to regulate content on the internet. But essentially what it's aiming to do, or how they're framing it at least, is they want to impose an obligation on big tech companies to address on their platforms content which is verifiable as false, misleading, or deceptive, and which would cause serious harm. And serious harm, for instance, can be harm to the economy, harm to democracy, harm to people, harm to public health. It's very broad. It covers pretty much every aspect of public policy that you can imagine. So it will do this by imposing an obligation on the companies to essentially draft codes detailing how they will deal with this content. And if they're deficient, then the communications regulator, ACMA, will set standards that those platforms have to comply with. And if they're still deficient, they can impose immense fines, totaling, I think, under the bill, $100,000 per breach by the company, or 5% of the company's annual turnover. So the immensity of the penalties will induce the big tech companies to mitigate their risk by essentially over-complying. And the government's admitted that there is a real risk of over-compliance, and they don't care about that. Now,
Well, I wouldn't care about it because I think that's the intention.
Exactly.
It is not to attack it is not really to attack the platform. It is to attack via the platform the content that appears on it.
They're essentially outsourcing to these entities the enforcement of government censorship. And just to prove that point, so they'll impose these obligations. There's big penalties for failing to address the misinformation and disinformation, but there's no equivalent penalties if you censor content that is not misinformation. So it's all one way. Now, what's interesting for our discussion is the issue of what does this mean for referendums? It's a question that I come back to. And referendum discourse in Australia is very relevant. Even going back decades, people talk, the intellectuals, the media, political class in this country talk about the reason referendums are defeated in Australia is because, no voters are either unintelligent or they've been misled, or some combination of the two. So there's this great deal of concern that people need to be protected from themselves by imposing on whoever, in this case, digital platforms, clearing up the debate in their sort of kind of framing. We had in last year, following the voice referendum, this was the big complaint from Yes campaigners, which was that this was the leader of the Yes campaign himself on the night of the referendum. Thomas Mayo said, Dean Parkin, said this was the biggest misinformation campaign in Australia's history, and the No campaign was based on lying to the people.
Yeah.
This is the context. We know in Australia's history, there's a great deal of concern about misinformation or misleading content, which is swaying people to vote no at referendums. And now, one of the harms that is listed in this bill is harm to the integrity of a referendum process. So it's specific. It's completely expected, and I think we should expect that at a future referendum on the monarchy, that there will be biased treatment against essentially the conservative perspective.
All right, so 1999, too much detail leads to failure. 2023, no detail, trying to get it through on the vibe of the thing, emotional rhetoric, failure. Subsequent referendum in the future, no campaign.
Yes. I think there's another reason why referendums fail, and that is that in the history of Australia, there has been no successful referendum unless there is bipartisan support. Now, what this attempts to do, according to Morgan's understanding, which I accept, what this seeks to do is to muzzle the bipartisan aspect of it by saying, well, you have to agree with us because everything you say in opposition is misinformation. And I think the other concern that I have, apart from those obvious issues, is that it seems to me, as I understand it, I have a very superficial understanding, and I want that to be made clear, but as I understand it, there is no immediate right of review as to something being classed by some external entity that what is sought to be published is misinformation. So that's one aspect. The other thing is that surely if one is to have a fair go at a referendum debate, you have to set up separate social media platforms outside of the large platforms so that you can get your message out and say that is not misinformation. I'll listen to what they're saying, it's not.
Well, it's funny you touch on that. Even the smaller platforms, and even not even social media type platforms, digital content providers could be at risk. I've just written a piece in The Spectator Australia that came out yesterday, which made the case going through the legislation that something like The Spectator or another magazine I write for, like Quadrant, could be eligible under having to subscribe to ACMA directions simply because they have comment features on their digital article offerings, and they connect users, and users who engage in an interactive feature on a website, that website is classed as a digital content service or a connective media service. That's it. That's the phrase. And then that is classed as a section of the digital industry and so on. Okay. It is quite incredible to me that this is a piece of legislation being put forward in Australia.
It's a propaganda machine.
It's propaganda.
By another name, but it's part of the stealth that we've been talking about.
And it's forced bipartisanship too. I think it's not a case of muzzling bipartisanship. I think it's a case of achieving bipartisanship from destroying completely the other partisans in another interpretation. So, okay, question then. We were talking about the Governor-General. We were talking about the Governor-General's powers and responsibilities under the Constitution, but perhaps, may I say, moral responsibilities as well, and we rejected a lot of her partisan positions. So I'm interested to see where the intersection between morality and legislation or policy is. So, Philip, yes or no, and then explain. If this bill passes the Senate, should the Governor-General, under the Constitution, exercise reserve powers and refuse to grant royal assent to this bill, therefore terminating it?
I believe so, but she won't.
I know that she won't. I think, I think it may be in her interests for a bill like this, but why do you think she should? Because a lot of people would think this will set a precedent, suddenly everything will be being rejected. Why do you think so?
The bill goes far too far and will be used by a government to silence its opposition. It will be used by social media to silence policies that it does not agree with, or ideology it does not agree with.
I agree with that. I think that is the effect of it. The question is, should she do it for any other reason other than the morality? I have a view about morality and the law. I don't see a separation between the two.
Okay.
I think the legal system is just another
Codification.
source or codification of moral issues, whatever they might be. And when we may have moral differences with the law, it doesn't mean that the law is immoral. It's just a different morality from the one that we think should be espoused. But I've got another way of viewing this. Yes, she should reject it. She won't. But the High Court has been at pains over some decades now to uphold a right of freedom of communication on political matters. And legislation has been invalidated where it contravenes or runs aground against that right. And so there is an immediate question as to whether these laws, given the implications of them, are constitutionally valid when tested against that implication that the High Court has made from our system of government, which implies a right to be heard and to contest ideas. Now, if that right is abrogated or taken away by this legislation, then it may be invalid, and if the Governor-General doesn't do the right thing, one would hope the High Court would.
But of course, we have a different sort of High Court than we did, say, 10 years ago. We have a High Court that does not only look at the law, the letter of the law as it should, but also brings in other factors, as say the American court has done, the British courts have done, and this is totally wrong, because the High Court should look at the law and only the law.
We'll come back to the High Court.
Yes, but may I just add something to that? It is true that policy considerations come into greater consideration than maybe they did previously on black letter law questions. But this is a policy question. And so one would expect that the High Court, because the implication is a policy implication necessarily drawn from the black letter provisions of the Constitution. When it comes to black letter questions, like the ones we were discussing yesterday, how in order to be to sit in Parliament, one has to swear and subscribe. That's the sort of thing on which the High Court always has been and still is very good. On a policy question like this as to the implications of this legislation, it makes it harder to predict the outcome, but it certainly is on good ground to say that this diminishes that implication and so therefore diminishes a constitutional right and cannot be upheld as being valid. There's another question as to whether, as a characterisation question, it falls properly within Section 51. I don't think that's going to be a major problem for the government because they can attach to one or more powers fairly readily. But when you look at the word communication, just the word communication, communication is a two-way street and it has no implied limitations upon it. And political communication has no implied communication barriers brought into it. But when there is a mechanical diminution of the communication, and when the right to decide whether a communication is a communication or not is delegated to non-governmental bodies, then I think the High Court would see that that may be a short route to a totalitarian regime by which corporations run our lives rather than the government.
So in the High Court we trust, I suppose.
Well, it's interesting just thinking of the High Court. At least in my view, the High Court's very well positioned to deal with the written constitution and matters arising under the written constitution. What my supposition would be is I think the role of the Governor General in refusing assent is in matters that address or deal with the unwritten constitution or the founding traditions of the Commonwealth itself, to which there is no one else that can defend them. And the question in my mind would be, are the provisions of this bill so offensive to the kind of founding conventions and traditions of Australia itself that it cannot be passed in this form? And I think you can make an argument that the sheer breadth of this bill in attempting to address or minimise or censor the broader Australian public on matters of public debate do violate what are, the common law rights of Australians to engage in the public debate, which actually forms the foundation of a Westminster democratic system. So I think there's definitely, a case for the refusal, at the very least, to send this back to Parliament and say, behind closed doors, to send it back to Parliament and say, try again, at the very least.
Look, I have a very basic interpretation of this. If the Australian Parliament was to pass a law legislating and allowing for slavery, I would expect the Governor-General to refuse assent.
Yeah.
Now,
or if the government, if it was a Labor government that passed legislation to prohibit the existence of the Liberal Party.
Yes. Yes, and look, the Menzies referendum to ban communism failed because I think, and Menzies later regretted this, I think, that because there's not an appetite to search and destroy totally. There is, and this is why we do something like this, there is an appetite for informed discussion and debate. That's what I think.
Well, going back to cases like the bank nationalisation case, which again was, although it was a legal argument, it was certainly a policy argument as well. Our High Court has been very different from what we see in the Supreme Court of the United States. First of all, I have the personal opinion that the intellectual stamina of our High Court is second to none. It is a very, very good court. One may not agree with everything that every member of the court either says or believes, but they are there on merit, and one need only look at some of the recent appointments to the Supreme Court of the United States compared with some of our recent appointments, and they are so intellectually superior and such good lawyers that we are in at least in the first instance, in safe hands. Whether that means you'll win or lose on a particular argument is not to the point, but this court is not another level of legislature like the Supreme Court of the United States has become. So I think, yes, she should refuse it, but if not, let's race off to the High Court.